So, good morning to everyone. I request Advocate Preeta to welcome the gathering and also the speakers, the experts on this field, and introduce them. Advocate Preeta, are you ready?
Good morning, one and all present here. A warm welcome on behalf of KSR and Co, the entire team of KSR and Co. I would like to welcome you all for this wonderful event, for sparing your time and attending this event. To introduce about the speakers, we have two speakers here. One is S. Jayalakshmi and Shruti. To start with S. Jayalakshmi, she's an advocate by profession. She's also an associate company secretary. She has been associated with our firm for more than 6 years, and she's an expert in case laws research and analysis of case law. She has represented our firm, our clients before various tribunals. Next comes our other speaker, R. Shruti, who's also an advocate by profession. She's pursuing her company secretary course. She's in professional program, final level, and she's also associated with our KSR company secretaries for more than 2 years. She also handles matters relating to IBC. She has been handling our IBC matters from preparation level of preparation of pleadings till representing our clients before various tribunals. I would like to welcome our speakers to take over this session. Thank you. Thank you.
Good morning, everyone. And today we have two bright young ladies in front of all, having good experience in this field. And the interesting part of IBC is that it is also an young law. And therefore, it doesn't really matter whether a person has so much years of experience and all, except that in the background of your mind, sometimes you may be working on the earlier presidential towns or provincial insolvency and something like that. Similarly, you would have had some baggage of information about the earlier era of the Board for Industrial and Financial Reconstruction, about the earlier era of Companies Act, winding up of companies, liquidation, voluntary or non-voluntary, shareholder or creditor mood. So those baggage will always be running in your mind, and you will be looking at every provision in the IBC, be it the commencement or the misfeasance and surcharge avoidance transactions. You will always be probably having a notion initially because of your earlier experience, and thereafter you will be comparing it, and thereafter you will be trying to see whether this is good or that is good, or this way or that way, it was not like that and all. But whereas the young professionals in front of you today do not have probably that earlier baggage, earlier influencing factors, and they will look at the law as pristine as it is. In a fresh, innovative manner, the law has come. It has been structured in this way. Of course, the result of this law, insolvency resolution, has sent several people to Parani and Tirupati. Is a different topic altogether. Yeah, that is an outcome. It is an emerging outcome. Like Supreme Court said, economic experimentation. There must be sufficient play at the joints. You should be able to do yoga. June 21 is following quickly. So in this backdrop, I thought we should invite these bright professionals to give us a perspective of certain judicial precedents which have come to be, given by none other than the apex court of this country. And I would definitely want to record here that in this law, we were able to see whole lot of professionals, whole lot of regulators, administrative mechanisms, judiciary, tribunal, appellate tribunal, Supreme Court, High Court, all these actors in the entire drama, I can say drama once again, that all of them have performed efficiently, delivered goods faster than ever before. In this backdrop, may invite Shruti and SJ, we call her SJ, S. Jayalakshmi actually, to deliver their part of the presentation on the important precedents set out by Supreme Court of India on insolvency and bankruptcy code, probably corporate insolvency resolution process. Go ahead, Shruti and SJ.
Yeah, sir. Thank you, sir. Thank you. Good morning, everyone, and a warm welcome to everyone over here. And you have to bear us for 1 more hour to take on this. Thank you. So today we have split the session into two parts, and the first session will be taken over by me, and the next will be continued by my fellow colleague Shruti. So I will just start to share my screen. Yeah. Our topic today is decoding Supreme Court settled propositions of law relating to CARP process. So we are going to get through all the Supreme Court settled propositions over our topic. So what is DQ and why it is important under insolvency law? What is actually
SJ, you can make it full screen, please.
Screen is not shared or what, sir?
It's not full screen.
Oh, okay.
You will right hand side paranga. Right.
Visible, sir?
Yeah, now it's visible.
Yeah, thank you. So why is DQ important here? I have just kept DQ for fancy thing like what is actually DQ with debt, default and non-existence of dispute. Let us see first on debt. What is actually debt and why it is so important? What are the 3 things, debt, default and dispute? Why it is sine qua non for initiating an action under insolvency code? So what is debt here? Let's see what is debt and debt, why it is so important. Debt is nothing but a liability or obligation with respect to a client. So, okay, there is a debt. How a layman would know that is a debt and should be initiated under the insolvency law? What is the debt? And whether it is a financial debt or operational debt, how a layman would know, how he will know that it is a financial debt. Let's go with the Act, what it says about financial debt. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes. It has given some examples of financial debt. What here we have to look into is a financial debt along with interest, if any. So there has been a decision on this that whether a financial debt should be along with interest, only with the interest whether a financial debt should be filed, whether an action should be initiated. It is a question before the court. But what held is financial debt can be only without the interest compound can be filed. It is not a necessary component. The interest should be present with respect to financial debt. Let's see what is an operational debt. Operational debt means the claim in respect of the provisions of goods or services or a debt in respect of payment of dues arising under any law for the time being in force. So an operational debt means the claim which is with respect to provision of goods and services including employment. So for example, salary arrears can also be claimed as an operational debt. So an operational debt definitely should be with respect to a provision of goods or services. So next, okay, fine. There is a debt. That is a financial, that may be either financial or operational debt. Okay, what is with respect to default? Whether such debt should be defaulted? How it can be defaulted? That default can be whole or for any part or installment of the amount of debt, as the case may be. So, for example, a company proposes a dividend. Until and unless it is declared and not paid, it does not become undefaulted and does not become a debt. So that is what I want to insist on this. Okay, fine, there is a debt that is defaulted. What is the defense available for the corporate debtor? That is a dispute. There should be an existence of dispute to prove there is an existing dispute with respect to this. So, okay, there is a debt defaulted and there is a non-existence of dispute, for example. So, what is the claim? Claim is coming everywhere. So, let us see what is a claim means. Claim means a right to payment whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. So a right to remedy for breach of contract also comes under the ambit of claim. Okay, for example, if we say a right to payment, whether or not such right is reduced through judgment, if we take a recovery certificate, if we say, for example, a decree holder, whether he will comes under the purview of court, whether he can claim himself as an operational debtor or the financial creditor. So let us take you through this. A decision of SR Steel of Committee of Creditors versus Satish Kumar Gupta. Though the SR Steel Committee of Creditors versus Satish Kumar Gupta case have some more proposition, I'm taking you to this with respect to the contingent claim. What the court has said, what is the apex court has said with respect to the contingent claim. I want to explain this with an example. That for example, a resolution plan has been implemented and it has been approved by the adjudicating authority. Then before the approval of the resolution plan, the claim is not crystallized. After the approval of the resolution plan, it has become crystallized. What will the position of that creditor? What will happen to the resolution applicant who have successfully overcome the resolution plan? So what the court says here is all claims must be submitted to and decided by the resolution professional so that a prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. This is a successful resolution applicant, thus on a fresh slate, has been pointed out by us here and above. What the court says is that successful resolution should not be burdened with the over and over of the claim. That should be debt before the approval of the resolution plan. So, a contingent claim cannot be claimed after the approval of the resolution plan has been proposed by the SRC case. But later on a case, Fourth Dimension Solution versus Retro India Limited, that is on 21st January, what the court said is arbitration proceedings has been allowed to continue after the approval of the resolution plan. The SC held it is stated that some arbitration proceedings were pending between the parties. If so, all the contentions are available to both sides to be decided in the said proceeding on its own merits. So this is totally a contrast with the clean slate doctrine propounded by the Supreme Court in the SRC. So let's come with the Kotak Mahindra versus Balakrishnan case. In this case, what happens is whether a recovery certificate holder is a financial or operational creditor, between which year he has to file. In Kotak Mahindra case versus a Balakrishnan case, what the court is, okay, there is a default and debt and claim is also there, but the court said the definition of section 5 of the clause 8 says the definition is inclusive and not exhaustive. Taking into consideration the object and the purpose of the IBC, the legislature could never have intent to keep a debt which is crystallized in the form of decree outside the purview of section 5 and clause 8 of the IBC. It went on to say that having held that liability in respect of a claim arising out of a recovery certificate would be a financial debt and such person can initiate an action under the IBC. So what is with respect to claim on payment of interest is actually a debt? There are so many questions that arose that with respect to the interest part which has been yet to be decided by the SE, but there are different views by the NCLT and NCLAT with respect to the interest subject. What NCLT in the matter of SS Polymers versus Kanodia Technoplast held is dismissed the petition of section 9 saying that only a realization interest amount is a gross misuse of the IBC process as a recovery mechanism. So what is here the court says is the payment of interest alone cannot be filed under section 9. Maybe it can be clubbed with together the principal and interest and not to be claimed alone for the interest part alone. This has been held in this case. So here comes the next, the existence of dispute. What is the existence of dispute? This is the defense available for the corporate debtor to defend himself in the demand notice. So when will he be able to prove himself is when a section 8 demand notice has come, he can reply in the notice to the demand notice by claiming there is an existence of dispute and proving it. So the concept of existence of dispute raises so many questions amidst the filing the application of section 9. The existence of dispute comes from section 8 to A, wherein the corporate debtor on receipt of demand notice shall bring to the notice of the operational creditor that there exists a dispute between them. Now, I'm going to the important and the famous judgment, Mobilox versus Kyrgyz software case. I promise and I guess that anyone of whom here would have been practicing the field of IBC would have definitely used this Mobilox case, at least in one case. That much famous and important, and the clarity has given by the SE in this decision with respect to section 9 application. So what it says is, and it has given a beautiful explanation for what are the criteria that has to be dealt by an adjudicating authority while evaluating the Section 9 application. The only thing remains changed is the criteria and the threshold limit of 1 lakh has enhanced to 1 crore. So what has been held in this case is, there is a debt that should be an operational debt as defined under the code, and it must exceed the threshold limit, which is 1 crore. And whether there is sufficient evidence to prove the debt, and there is any existence of dispute. So these are the three criteria that have been provided by the Mobilox versus Kiruzar case, that there should be an operational credit as defined under the code, and there should be exceeding the threshold limit mentioned, and there should be sufficient documentary evidence to prove the same. And if there is any defense for existence of dispute, that has to be brought, and that defense should not be a spurious one, and the dispute is not a patently feeble argument or an assertion of fact supported by evidence. Interestingly, while the court was of the view that it is important to separate the grind from the chaff and to reject the spurious defense which is mere bluster, I'll just tell you with a case that if a Section 8 demand notice has come and the corporate debtor, for names that he is just claiming that I have been disputed, there is a mail correspondence between us, there is a quality dispute, like that. These are the examples that a mere bluster they can give, that these defense should not be taken into account, that a court should separate the grain from the chaff. That has been held by this case, followed by a Cape Howard case. In Cape Howard versus Overseas Infrastructure Alliance case, the court has repeatedly held that it is important to separate the grain from the chaff and to reject a spurious defense which is mere bluster. This has been held in this case. So let us go to the next topic. Overriding effect. What is overriding effect? What it all talks about is nothing but Section 238 of the code states, the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any such law. What it is saying is, if there is a two special statutes and containing a non-substantive clause, which one will prevail? That has to be decided. And in IBC it has said that Section 238, it is saying IBC will prevail over all other special statutes containing non-substantive clause. I could explain with a better example, that let us take Section 28(a)(3) of the SEBI Act, which says the recovery officer will have precedence over any other claim against such person, whereas under Section 53 of the IBC says the proceeds from the sale of liquidation estate would be distributed in the manner specified therein, which prevails over any other law contrary to the same. Okay, there is two special statutes, SEBI Act and the IBC. In Section 28A also they are saying recovery officer will have precedence, and Section 53 also, Section 238 also says IBC have precedence. Now, which one will prevail? What are the other special statutes having a non-substantive clause, and I will get you through the SC decisions. Okay, in Insolvency Act, what it is there is, under Section 26E, it says priority to security creditors, notwithstanding anything contained in any other law for the time being in force, after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts, and all revenues, taxes, cesses and other tax payable to the CG or SG or local authority. But after the commencement of Insolvency Act, it has brought an amendment on 24 January 2020 saying, in case where the insolvency or bankruptcy proceedings are pending in respect of secured assets of the borrower, priority to secured creditors in payment of debt shall be subject to the provisions of that code. It has been clearly mentioned, if there is a dispute between Insolvency Act and IBC, then IBC shall prevail with respect to secured creditors. Also take Income Tax Act Section 178, which says where there is a company in liquidation and the liquidator has been appointed. The liquidator has to communicate to the assessing officer, and without the leave of the VC shall not part with any of the assets of the company in liquidation, except for paying the tax and making payment to secured creditors. But this has been amended, and Section 178 has stated that the provisions of this section shall have effect notwithstanding anything contrary to contained in any other law, but except the provisions of IBC. So, on 1/11/2016, the amendment has came with respect to Income Tax Act, and it also says IBC will prevail over Income Tax Act. Let us see how the SC handled this situation. In innovative industry, which is the first case, for Section 238, Maharashtra Act and the IBC were contrasting each other, and Maharashtra Act will not prevail over the IBC as a moratorium was declared. Further, it held it is precisely for this reason that the non-obstante clause, in the widest term possible it has to be looked into it, is contained in Section 238 of the Code, so that any right of the corporate debtor under any other law cannot come in the way of the Code. It has been held in that case. What happens in the Principal Commissioner versus Mona Tispat case? It says its progeny, making it clear that the income tax dues, being in the nature of crown debts, do not take precedence even over secured creditors who are private persons. So it has been consistently saying the Section 238 will prevail over any other law. In Verma Ispat versus Directorate of Enforcement, it has been held by the NCLAT. I am just taking you through this NCLAT and High Court decision to explain with respect to Prevention of Money Laundering Act. So, as per Prevention of Money Laundering Act relates to different fields of the penal action of proceeds of crime, it invokes simultaneously with the IB Code, having no overriding effect of one act over the other, including the IB Code. What NCLT said in this case, the Prevention of Money Laundering Act will not override the IB Code, and they both are simultaneous proceedings, and the PMLA is with respect to the penal action of the proceeds of crime, and that will not override with IB Code. It has been held. But later on in the Nitin Jain versus Enforcement Directorate case, the Delhi High Court held. Let us see what is the fact here. The fact is that there is a CIRP process was initiated and the petitioner was appointed as the liquidator. During that time, the liquidator has not met with any summons. It was during this time the liquidator was called on by the enforcement director for the first time. So subsequently, an offer for sale of corporate data was made by Lucky Holdings, whose resolution plan was approved by the adjudicating authority. It was provided that the distribution of assets of the corporate debtor would abide by Section 53 of the IBC. However, when the matter came up for hearing before the Delhi High Court, the ED had not passed a provisional order of attachment of the properties. Thus, the primary condition that came up for consideration before the Delhi High Court was whether the scheme of liquidation would get inhibited by the statutory process for attachment of properties provided under the PMLA Act. So, what has been held in this case is the court also bears in mind that the bar stance that created under Section 32EA operates and extends only insofar as the properties of the corporate debtor are concerned, that statutory injunction does not apply or extend to the persons in charge of the corporate debtor or the rights otherwise recognized to exist and vested in the respondent to proceed against the other properties. So, what is the conclusion here is where two statutes contains non-obstante clause, then the later statute must prevail, because if the legislature still confers a later enactment with a non-obstante clause, it means that the legislature wanted that enactment to prevail. If the legislature does not want the later enactment to prevail, then it could and would provide in the later enactment that the provisions of earlier enactment continue to apply. In such case, the later enactment IBC will prevail over the other laws and having an overriding effect. Okay, next we go to the next topic, equitable treatment for similar creditors. The treatment of various classes of creditors in the scheme then existed has been a matter of debate at various levels and in several decisions. It acquired attention of the legislature that the balance was required to be brought about in treatment of different creditors, and critical gaps were noticed in the CIRP framework. After the amendment on 16th August 2019, is that the resolution provisional shall examine each resolution plan received by him, confirms for payment of CIRP costs and for operational creditor and for the dissenting financial creditor, which shall not be less than the amount to be paid to such creditors in accordance with subsection 1 of 53 in the event of liquidation of the corporate debtor. So with this amendment, the legislature not only provided the entitlement of minimum amount for the operational creditors, but also paved the way for dissenting financial creditors who would be paid a certain minimum amount which would not be less than the amount to be paid in the event of liquidation. So, as I earlier said, SRC has given so many propositions with respect to other things. In this proposition, I am taking as equitable treatment is to be accorded to each creditor depending upon the class to which it belongs, secured or unsecured, financial or operational. Fair and equitable dealing of operational creditors' rights under the said regulation, which involves the resolution plan, which is not the same thing as saying that they must be paid the same amount of their debt proportionately. Also, the fact that the operational creditors are given priority in payment over all the financial creditors does not lead to conclusion that such payment must necessarily be the same recovery percentage as financial creditors. In SRC, what they are saying is that the financial creditors will be treated as same with the financial creditors of that class and not with the other class. This has been held in SR case. So, following the decision, J.P. Kennington Boulevard versus NBCC on 24th March, it was held. We would happen to observe that in a case, a dissenting financial creditor is a secured creditor and a valid security interest is created in his favor and is existing. What will be the situation? And the court held, obviously, by enforcing such security interest, a dissenting financial creditor would receive payment to the extent of his entitlement and that would satisfy the requirement of section 32B of the code. In any case, that is whether by direct payment in cash or by allowing recovery of amount via the mode of enforcement. So in this case also, what they are saying is dissenting financial creditor would be entitled to that amount he is entitled to as per the enforcement of security interest and not an over above the security interest. So followed by that decision, India Resurgence versus Amit Metallics case, the issue arose was the main ground. In this case, what has been happened is the resolution plan proposed by Amit Metallics was approved by the Committee of Creditors, and the dissenting financial creditor is the Indian Resurgence. They are having a voting share of 3.94%, and they are the dissenting financial creditor. The main ground of challenge arose in this is they are having a valuation of security interest. And the resolution plan was approximately rupees 12 crore, which was not considered. So thus the approved resolution plan failed to regard the interest of all the stakeholders, including India Resurgence, who was offered a meager amount of slightly over rupees 2 crores. For 12 crores, they have been awarded only 2 crores, and that was challenged by the dissenting financial creditor. So what has been held by the court is the limitation on the extent of the amount receivable by a dissenting financial creditors is innate in section 32B of the code and has been further exposited in the decisions aforesaid. It has not been the intent of the legislature that a security interest available to a dissenting financial creditor over the assets of the corporate debtor gives him some right over and above other financial creditors so as to enforce the entirety of the security interest and thereby bring about an inequitable scenario by receiving excess amount beyond the receivable liquidation value proposed for the same class of creditors. It is again and again reiterating that the class of creditors will be treated among themselves and there will not be any inequitable scenario will arise between the operational and financial creditors. And the last decision it has been held latestly is Pratap Technocrats versus Monitoring Committee of Reliance and Total. In this also they are held. It is what is fair and equitable between the operational creditor as a class and not between the different classes of creditors. The statute has indicated that once the requirements of section 32B are fulfilled, the distribution in accordance with its provision is to be treated as fair and equitable to the operational creditors. In this case also, it has been held that the equitable proposition here is that operational creditors will be treated at par with their class of creditors and not with other classes of creditors. With the financial creditors, unsecured and unsecured will be treated at their own class of creditors and there will not be any inequitable situation arises. And this is the proposition held by the Supreme Court. And thank you. I will just let my colleague Shruti to take over on the second part of session. Thank you.
Can I begin? Am I audible? Thank you so much, SJ ma'am. Hello and good morning to everyone. I'll be taking this session forward and my presentation will be confined to 3 topics. First will be commercial wisdom. Second will be with regard to Limitation Act. And third will be withdrawal under Section 12A. Let me just share my presentation.
So the first topic is commercial wisdom. We all are aware of the famous cases, which is Swiss Ribbons and the SR Steel case. We are aware of the Swiss Ribbons case and the SR Steel case, in which the commercial wisdom of the COC was held to be supreme. And we know that the adjudicating authority's role when it comes to deciding upon the commercial wisdom is very, very limited. And there are only, in fact, 2 sections under which the commercial wisdom can be decided by the adjudicating authority. So the 2 relevant sections are, first is the section 32, which is for the NCLT level. And the second one is section 61, which pertains to NCLAT when it comes to in case of an appeal. So for the first section 32 states that the resolution professional shall examine each resolution plan which is received by him to confirm that the resolution plan pertains to all of these things, that it confirms to these clauses, which is firstly that the CIRP cost is going to be given priority above all the other debts which is going to be paid under the resolution plan. The second one is treatment of operational creditors, that they have to be above the amount that they are going to give in case of liquidation, or that the amount that would have been paid to the creditors if the amount has been distributed as per section 53 waterfall. So the third one is the management of affairs of the corporate debtor. Fourth is that the implementation and supervision, whether they have been provided under the resolution plan. The fifth and sixth point are that the resolution plan does not contravene any of the provisions of law, and that the plan in fact conforms to all of the requirements which is specified by the IBBI. So now in case of appeal, the similar grounds are provided so that the adjudicating authority can sit over in deciding the commercial wisdom's justiciability. The first one is whether the approved plan is in contravention of, in case the approved plan is in contravention of the provisions of law, if there is any material irregularity in the exercise of the powers of the RP during the course of CIRP. The third is debts owed to the operation creditors have been in fact provided as per given under the IBBI. CIRP costs have been provided in priority to the other debts, and to ensure that the plan does comply with any of the criteria specified by the board. To deliberate upon the commercial wisdom and the adjudicating authority's justiciability, we are going to be sticking on to 4 case laws. The first one is the Shashidhar, the current urban case, Kalpraj, and the latest Shiva Industries case. So moving on to the first case law, which is the case Shashidhar versus Indian Overseas Bank. So what has happened in this case is that there are 2 resolution plans which have been put forward to the COC. Unfortunately, both the resolution plan did not garner the support of the then 75% which was required for a plan to be approved, to be considered to be approved. Both the plans did not garner the 75% approval. So the corporate debtors managing director of PIPL approached the NCLT and stated that the votes and majority of the financial creditors who did not participate in the voting shall also be counted for the purpose of votes. The NCLT Hyderabad unfortunately allowed such a petition filed by the corporate debtor and approved the resolution plan or the revised OTS, which was as submitted by the resolution professional. Now, aggrieved by such a decision of taking the votes of people who are not participated, 3 financial creditors, which is the IOB, Central Bank and the Bank of Maharashtra, approached the NCLAT. The NCLAT, in fact, dismissed the order of the NCLT and stated that the resolution plan cannot be approved, and the 75% requirement is of people who must be taken of the entire voting share of the financial creditors, and therefore the resolution plan stood rejected. Now, the Supreme Court simply said that it shall not sit over the decisions of the COC. Under paragraph 57, we are able to see that the Supreme Court observed that the provisions investing jurisdiction in itself is not with regard to whether the COC has approved the resolution plan or rejected the same, but only with regard to an approved resolution plan. that too under the limited review which is provided under section 31. Under paragraph 44, it states as follows. At the best, the NCLT may cause an inquiry into an approved resolution plan alone, and that too under the limited grounds which is referred under 32, read with 31. And therefore, it stated that the NCLT has in fact gone in of excess jurisdiction to look into this and to undertake a scrutiny of the justness of the opinion expressed by the COC at the time of voting. Under paragraph 52 again, it states that upon receipt of rejected resolution plan, the NCLT is not expected to do anything more, but is simply obligated to initiate a liquidation process. We are also able to see that the Supreme Court has in fact again stated the COC's supremacy, that the COC has been given the paramount status. It is assumed that they already have they are already fully informed about the viability or the feasibility of any resolution plan, and that the legislature has in fact taken a conscious decision as to why it has included such only a limited provision for review. Now we're moving on to the next case which has decided upon the commercial wisdom. Now in this case what was challenged is the resolution plan's feasibility and viability. Now in section 7 application was by the financial creditor was admitted, and the bench approved a resolution plan of one Sai Agro India Chemicals. The director and promoter of the corporate debtor challenged the order of the NCLT on the basis that the resolution plan was not feasible because there was one ethanol plant and machinery which was not. It was an allegation that the ethanol plant and machinery was not considered under the resolution plan because the plant was in fact subject matter of another dispute. But the Supreme Court, after going through the arguments and after going through the records, it understood that three parties who were involved, which is the successful resolution applicant, the resolution professional, and the COC, have in fact taken note of such a plant, that the plant was in fact under dispute. And if you see it is observed that under the resolution plan, there was a provision for capital expenditure, which is in fact including the cost of ethanol plant. And additionally, it was also noted that the bank which in fact holds the symbolic possession had approached the SRA for its sale. So taking note of such records and such observations, the Supreme Court went on again to hold that the COC has paramount status and the adjudicating authority has to simply not look into the resolution plan and adjudicate it. Then the adjudicating authority will have to switch over to the hands of more, and therefore the resolution plan was stood to be approved and the appeal stood to be dismissed. The next case we're going to see is about the Kalpraj Dharmshri case. In this, what was challenged was with regard to the resolution professionals' duties under the CIRP. So what has happened is that the Section 10 application by the corporate debtor himself stood to be admitted. CIRP began. Form Gs were issued. So the fifth and last Form G came to be published on the 11th of December 2018, in which it stated that the resolution plans have to be given to me before 8th of January. Now we have 3 resolution applicants who came forward and submitted the resolution plan. Unfortunately, they have submitted the resolution plan beyond the period which has been specified in the Form G. Now, Kotak, which is the Kial, sent an email to the RP stating that how can you accept such a resolution plan of Kalpraj because it has been given subsequent to the Form G's date. However, in the meeting of the COC, it was decided by all the financial creditors that let us give a chance to all of the resolution applicants to come up with a revised resolution plan. Now, all of them came with a revised resolution plan, and subsequently, the Kalpraj resolution plan, the resolution plan of Kalpraj came to be approved by a majority. Now, after coming to know about such an approval and such an application to be made by the RP for the approval, Kial again submitted before the NCLT that made an objection to the resolution plan and stated that they cannot be approved given the fact that they have been given beyond the time which is prescribed under the Form G. The objections were raised against the alleged illegalities which were committed during the conduct of the CIRP. NCLT stated that it is a case where due opportunity was granted to all the resolution applicants, and moreover, the most resolution attractive plan came to be approved, and therefore your appeal is going to be dismissed. Now, again, before the NCLT, the NCLT, however, took a stand that the NCLT, in fact, committed a grave error in accepting such a resolution plan because it was submitted after the expiry of the deadline for submission for the plan. And without having to extend the timeline. Generally, once the Form G is given and the timeline is extended, it is decided by the COC that the timeline will be extended and subsequently the resolution plans will be received. But however, in this case, there was one Form G and subsequently resolutions have been submitted much later than the last date which has been prescribed. So what was the question is whether the NCLAT was right in law in interfering with the decision of the COC approving the resolution plan of Kalpraj. The Supreme Court simply stated as follows. It would thus be clear that the legislative scheme as interpreted by various decisions of the court is unambiguous. There is a limited scope and that is only which is provided under section 30 and 31. It can also be seen under paragraph 172 that the Supreme Court stated that it could be seen that all the actions of the RP have in fact taken the approval of the COC. So even if the resolution plans have been received subsequent to the date which is prescribed in the Form G and there is no Form G which is forming a basis of the resolution plan which has been approved, it has already been approved by the COC. Therefore, there is no question of adjudicating into it. That is the stand which is taken by the Supreme Court. It has stated that, however, it has been consistent stand of the RP as well as the COC that all the actions of the RP have been consciously approved by the COC. We also have a thumping majority of 84.36%. And again, quoting the paramount status of the COC, the resolution plans stood to be approved. It is also held that the NCLT has in fact acted in excess jurisdiction in interfering with a conscious commercial decision which was taken by the COC. So the last case coming under the commercial wisdom is Vallal RCK versus Shiva Industries, which is a 2022 case. Now what happened in this is that the Section 7 application came to be admitted by the NCLT. There was one resolution plan which is of Royal Partners Investment which did not receive the required 66% vote, and pursuant to which the settlement plan was proposed by the corporate debtor himself. Now, the settlement plan, in fact, came to be approved by, again, a majority of 94.23%. And since it came to be approved, the corporate debtor filed for an withdrawal under Section 12A. The NCLT stated that the resolution plan or the settlement plan, in fact, does not even look like a settlement plan. It, in fact, looks like a business restructuring plan. And therefore, by its order dated, the learned NCLT initiated liquidation. The NCLT again took the same stand and held that the settlement plan which is provided by the corporate debtor is looking like a debt restructuring plan. And they have stated these following grounds. They stated that it appears more like a corporate restructuring, business restructuring plan. There is not even a single penny has been received from the promoter under section by the promoter. And the COC has gone about approving the 12A application. It was also observed that the settlement plan provides for a payment of 285 crores within 180 days or from the date on which the plan is going to be approved, where in fact the whole infusion in itself is going to be 330 crores or loan. The resolution plan applicant is being ineligible has sort of found this way under 12A to give a plan under a thing of settlement plan and to withdraw the application under section 12A. It is also noted that the terms of settlement plan has also been vague. Now, under the Supreme Court said that this court has consistently held that the commercial wisdom of the COC has been given the paramount status. It is an intrinsic assumption the financial creditors are fully informed about the viability. So they have taken all the previous decisions of the Supreme Court and gone about to state that, to the end. Yeah. So the Supreme Court has stated that this court has consistently held that the commercial wisdom is in supreme, and it has stated that the resolution plan, in fact, when 90% or more of the creditors, in their wisdom, after due deliberations, find that it will be in the interest of stakeholders to permit the settlement and withdraw the CIRP, in our view, the adjudicating authority or the appellate authority cannot sit and appeal over the commercial wisdom of the COC. The Supreme Court has stated that the settlement plan has in fact been deliberated. The COC has considered the pros and cons of this settlement plan and thereafter has taken a decision, and therefore the adjudicating authority or the appellate tribunal cannot sit over any of the decisions taken by the COC, and thus the appeals to the allowed. We have finished the topic of commercial wisdom. Next we are moving on to the applicability of Limitation Act. So what is Limitation Act and IBC related? We have three relevant sections, which is the 238A, Section 18 and Article 137. So what does 238 state is that the provisions of Limitation Act shall apply to the proceedings of adjudicating authority, the NCLAT, and so on. Now, what is the period which is stipulated before which an application can be sought before any authority? Under Article 137, it is stated that since it is an application, there is a residuary provision which is provided, which states that any other application for which no period of limitation is given anywhere, 3 years shall be construed. And that 3 years shall run from the time when the right to apply accrues. So under Section 18, it also states that we have a period of 3 years. But such 3 years can be extended when there is an acknowledgement of liability in respect of such a property has been made by the party against whom the right is claimed or such a property is claimed. In such case, when the liability is acknowledged by himself, then you can extend the limitation period. So for this, we have these 4 case laws. However, we will not be going into the facts of each of the case laws. I will be taking through 5 or 6 propositions which came to be decided under these case laws. So the first one is the applicability of Article 137. In BK Educational Services, the Supreme Court held that the Article 137 of the limitation gets attracted. The right to sue, therefore, accrues when a default occurs. If a default has been occurred over a period of prior to the period of 3 years to the date of filing the application, such an application would simply be barred by 137, save as otherwise. If there is any condemnation of delay under Section 5, then that can be excluded. Otherwise, a period of 3 years will be standing to be applicable. So the second is the retrospective effect of 238A. In BK Educational Services again, the Supreme Court opined that the Section 238 was in fact clarificatory in nature and it's a procedural law. So once it becomes a procedural law, the law stands to be applying in a retrospective effect. It states that in case 238 is not going to be applicable and in case we are not taking the retrospective effect, it will turn into a situation where some of the cases will be, in some set of cases the 238 will apply and some set of the cases 238 will not apply. And the court adhered to the principle that the right to sue, in fact, accrues on the date on the default occurs. And if the default occurred even 3 years prior to the date of filing of the application, the same cannot be treated as a debt which is due and payable or a debt which is due. Next, we're moving on to applicability of Section 18. So Section 18, in the Bapulal case, it has also quoted many of the previous judgments to save some of the very conclusive findings. The first one is that the code is in fact beneficial, has to be beneficial to the corporate debtor. There cannot be a situation wherein the corporate debtor is burdened with many applications which are in fact time barred. And therefore, we construe that the code in fact was formed to be a beneficial legislation to the corporate debtor. So second one is that the intention of the code is not to give a new lease to the life of the debts which are in fact time barred. The third one is that the period of limitation for an application seeking initiation of CIRP under Section 7 is governed by 137. That the 137 article applies to applications made under IBC and therefore 3 years from the date of right to apply accrues. The last important thing is that an application made under Section 7 is not for enforcement of any mortgage liability. And therefore, Article 62, which states that 12 years, till the period of 12 years, you can enforce a mortgage liability, that Article 62 will not apply to applications made under IBC. So now, there were instances wherein the date of IBC was taken and therefore the extension of limitation took place. In the case of Sagar Sharma, it was conclusively decided that the date of coming into force of IBC has nothing to do with the extension of period. It states that it cannot form as a trigger point for a limitation for applications filed under the code. Equally, since the applications are petitions which are filed under the code, Article 137 of the Limitation Act will stand to be applied. The next one is the application of 62. So, with regard to mortgage properties, what is the law is that when there is money which is due from a corporate debtor, which is secured by a mortgage of an immovable property, then the period of 12 years will apply, because under the Limitation Act, under Article 62, you can enforce such a mortgage till a period of 12 years. Now, whether the IBC code applications can be filed within that period of 12 years from the date of mortgage, since Article 62 provides for the same. Now, under Bapulal, we can see that they have specifically disapproved such a contention, and they have also quoted previous case laws as the Gaurav Hargovind Bhai case, and also the Sagar Sharma case, state that the court has pointed out a fallacy in applying the period of limitation relating to mortgage for the purpose of applications under Section 7, and therefore Article 62 will not apply. So the last thing which we are going to see under the limitation aspect is the Lakshmipat Surana case, which came on in 2020. Now, what are the facts of the case is that there was a date of default which is given as specifically given in the application as 2010, which is the date of the NPA, and the bank has in fact sent a recall notice in the year of 2010 again. The case is that in 2007 and 8, the financial creditor has extended certain credit facilities to one proprietary firm, which is Mahavir Construction. The proprietary firm, such a credit facility was in fact guaranteed by Surana Metals Limited, which is a corporate debtor. Now, the application under IBC was in fact filed only in the year of 2019. We can say that the date of default is given as 2010. However, the application on the their IBC was made only in the year of 2019. The debt in this case was in fact time and again acknowledged by the corporate debtor, and lastly by the corporate debtor on the 8th of December 2018. So what was the question is that whether an action under Section 7 can be initiated by the financial creditor against the corporate debtor directly. In this case, the corporate debtor is the corporate guarantor concerning the guarantee offered by it in respect of a loan which is in fact by the principal borrower, who is a proprietary firm who has committed the default, instead of approaching the principal borrower firstly. The second question is whether the Section 7 application was barred by limitations, since the date of default is specifically given as 2010 and the date of application is in 2019. The NCLT clearly said that there's so much time difference is there and therefore the application is barred by limitation. The NCLT once again affirmed such a decision of the NCLT. However, the Supreme Court came about to state that that the financial creditor has not only the right to recover his outstanding dues by filing a suit, but also right to initiate resolution process against the corporate person, being the corporate debtor. In this case, it's being guaranteed by the corporate debtor, whose liability is coextensive with that of the principal borrower. So we can see that the debt is in fact owed coextensively by both the corporate debtor and by the corporate guarantor. And therefore, you can in fact approach the corporate guarantor, in this case the corporate debtor, corporate person, directly without even approaching the principal borrower. And we have seen that in the limitation that there is a latest letter in the year of 2018, which is in fact given by the guarantor. So that stood as an extension of liability. And since the debt stood to be acknowledged time and again, the court held that this is an extension of Limitation Act, and therefore the application stood to be approved. The court said that the principal borrower or the corporate guarantor admit and acknowledge their liability after declaration of NPA, but before the expiration of 3 years therefrom, which in fact extended, which including the fresh period of limitation due to successive acknowledgements. It is not possible to extricate them from renewed limitation accruing due to the effect of Section 18 of the Limitation Act. So such an acknowledgement, however, must be before the period of limitation. Para 49, it stated that a fresh period of limitation is required to be computed from the date of acknowledgement by the principal borrower from time to time, and in particular, the corporate guarantor by its last communication dated 2018. So the last aspect which we'll be dealing about is the very well-known aspect, is that the balance sheet acknowledgement will be construed as an extension of Limitation Act. It will give rise to a fresh period of limitation under as per Section 18 of the Limitation Act. So this has been stated in various case laws. I have just quoted all the case laws, and the proposition is that any admission in the balance sheet is per se an admission of liability. The last topic is the withdrawal under Section 12A, which has to be read in consist with Regulation 38 of the regulation. The first one, what does Section 12A say? The adjudicating authority may allow the withdrawal of an application which is admitted under Section 7, 9 or 10 on an application which is made by the applicant himself with the approval of 90% of voting share of the COC. So the three landmark decisions we'll be talking about today. One is the Brilliant Alloys, next is Navneet, and I have slightly detoured from the topic which says that we'll be discussing about Supreme Court cases. I have also taken one NCLT judgment, which is a Satyanarayan versus SB paper. The first case, Brilliant Alloys, is very simple. It simply states that according to us, this regulation has to be read along with the main provision of 12A, which in fact provides for no stipulation, and therefore an application for withdrawal under Section 12A can be made even post the date of expression of interest. But it, however, has to be before the plan has been submitted to the COC, before the plans are being discussed. Accordingly, we allow settlements that has been entered into and therefore annul the proceedings. So the next case law is the Navneet, which also states that even during liquidation, you can bring about a withdrawal application in the form of Section 230. And the last case is an NCLT Mumbai case, wherein it is an interesting case where we can see that the corporate debtor has filed an application under Section 12A. It is not an initiation by the financial creditor or the operational creditor under 7 or 9. It is an initiation by the corporate debtor himself under Section 10. So what has happened is that there was only one resolution plan which came forward by one resolution applicant. And the corporate debtor also simultaneously was negotiating with the RP for a settlement. So we are able to see that on one hand, the resolution professional has submitted a resolution plan, which is by that one sole resolution applicant who came forward, and side by side the applicant of the applicant of this miscellaneous application, who was carrying a parallel negotiation with the bank. Now, what happened suddenly was that the only sole resolution applicant which came forward in the COC desired to withdraw the resolution plan that he gave. So what are the questions before the NCLT is whether the applicant, who has himself only filed for a Section 10 application, can he himself go and withdraw his own petition by filing a Section 12A? And the second question is whether the resolution applicant has submitted a resolution plan which is approved and he withdraw the resolution plan. And the third question is whether the ex-director of the corporate debtor can offer a one-time settlement qualified under Section 29A. So what is the Supreme Court held? That the COC has only one financial creditor, Allahabad Bank, which has in fact examined the pros and cons of this settlement plan. This one-time settlement, we are able to see that the offer which is paid by the corporate debtor is for 18 crores in OTS, which is in fact higher than what the resolution applicant came to give under the resolution plan, which is of 12.5 crores alone. So the COC approved the resolution plan which is given by the corporate debtor, the settlement plan. So the one-time settlement plan was held to be a viable proposition in order to maximize the value of the assets, which is the preamble of the IBC in itself. And therefore, the resolution plan, the settlement plan came to be approved. And the resolution plan of the OTS of the corporators stood to be approved by the NCLT Mumbai. However, what has happened is that they have imposed two penalties. One is for this corporate debtor who came forward with an Section 12 application, while in fact he was the one who filed under Section 10 for initiation of insolvency resolution. So he was given a penalty of 5 lakhs, which had to be deposited within a period of 15 days. And then lastly, it also stated that the resolution applicant who in fact withdrew in the last moment, he had given an earnest money deposit of 50 lakhs. So the bench, the tribunal stated that the 25 lakhs has to be retained as a deterrence to be utilized towards CIRP costs, which was paid, and the other related expenses, and only 25 lakhs is directed to be refunded to the resolution applicant. Thus, we have come to the end of our presentation. I hope this session was useful, and I thank everybody for joining us today.
Yeah, it was, I can say, a wonderful presentation by somebody is talking. I'm also talking. It was a wonderful presentation by S. Jayalakshmi and Shruti. I was reminded by my friend from Mumbai, Mr. Rahul Sahasrabuddhi, saying that if you want a thing to be done well, do it yourself. He quoted Napoleon. But I now today say that Shruti and S. Jayalakshmi have proved the quote wrong, because I have entrusted this work to these two young ladies. They have done a brilliant work. And Napoleon has been proved wrong today. If you want to do a thing done well, do it through able people. And that is how I understand. It is not a joke to go through, the hundreds of pages of each decision, identify the core facts, connect it with the propositions, and do it. Of course, I would like to add my own quote also. Having listened to our friends here, you have all heard about various decisions beautifully presented as propositions. But, if you take the Antec case, December 2021, I would find in the Antec case, it was like, the resolution plan was approved. Then that Liberty took the liberty, DVA took the liberty. They wanted to withdraw another round of resolution plans, and 3 people bidded, and then liquidation was ordered, and thereafter another round was given. 70% approval, DVA's resolution plan came to be approved, but he wanted to withdraw. Ultimately, Supreme Court said nothing doing. There will be a contempt against you. Get this 500 crore credited to the COC. So, say Committee of Creditors in the Antec case, Supreme Court December 2021, 1st December 2021 is an interesting decision where we can only think one thing understand is wherever it is NCLT and NCLAT, they have certain limitations, including the Limitation Act, including the provisions. They cannot be seen as transgressing. But Supreme Court has always come to the rescue in complex situations. For example, in SR, I remember they gave a fresh start because 29A was for the first time introduced in November 2017. And another thing I remember now in the context of what our friends presented today, 44,000 or something was the amount received by the Committee of Creditors against 114,000 crores as the total value of resolution plan versus total value of debt on the balance sheet. I was told the promoters came forward and said, I will give you 55 instead of 44. Everybody was going by multiplication of 11. But nothing doing. You are not ineligible. Promoter is ineligible. Therefore, only resolution application, whatever is the amount realized, whatever is the haircut you need to suffer, let everybody suffer as per the system. Giving more than what the resolution applicant has proposed was not allowed for settlement. Contrast it with the cases that we have heard today, the resolution applicant, OTS, 12A, post-liquidation, 90% COC, and so on and so forth. And not to be left with, there is another interesting decision of Dr. Sanjeev, I don't know whether Dr. Sanjeev Khanna, Justice, and I always think Dr. Sanjeev Khanna. And he has rendered a very beautiful judgment, of course a very lengthy one, on pledge of securities in the demat form. Whether security interest is created, whether a person who is holding, that is a pledgee holding the, shares, he will be, when he is registered in the depository for the purpose of invoking the pledge as a beneficial owner in the records of the depository, will that per pledgee be considered as financial creditor, or has he invoked the pledge as appropriated the shares? It's a beautiful decision, because you are holding the pledge, you are invoking the pledge, you are taking your name as the beneficiary and put it in the records of the depository. But Supreme Court said 176 has to operate. You must give notice of sale. Thereafter, if you sell, you realize proceeds, then you are not going to be, for that amount, the financial creditor. Therefore, it's a beautiful judgment touching upon pledge, pawn, and 176, and therefore, you may have to apply thought on such very important decisions which will help us, because technologically, demat is a subject which we have understood in a better way over a period of time. Unlisted companies, public companies have to demat their shares. Their transfer is not permitted. Allotment is not permitted unless it is dematerialized. So, in a dematerialized world, we must remember how security interest must be protected. When security interest gets, extinguished, instead of that realization takes place, all those aspects can also be understood. So what I understand today is, under IBC, in the probably 5.5 years now, because come December it will be 6 years, we have seen a great path laid by various, the institutions and stakeholders. And only thing is, probably like NCLAT in a recent decision said, let us give some consideration for these operational creditors also, yeah. After all, they are vendors of goods and services. And why are you giving them, a very dry treatment? Stepmotherly treatment, I can say. So, that is the one thing I have always been thinking, that there is some sort of a discrimination, in my opinion, on the balance sheet asset. If any realization comes, disregard all these security interests and whatnot. If you want a resolution, let the resolution happen with the presence of everybody. Of course, remove all these interested transactions and avoidance transactions. Those things are very good. That has to be definitely taken care. And there shall never be a room for willful defaulters to enter through back door in what Shruti has said about an applicant under Section 10 submitting a plan under 12A to withdraw his own application. All these things probably, and we are all aware, a lot of things are happening in the this thing. All cases do not reach the Supreme Court, but whatever cases that have reached the Supreme Court, our friends have today explained in a very elusive manner. And I now invite Preeta to propose vote of thanks, because it is already time, and all participants, whoever has any questions, they can always email it, because it is 11:15, cases are there to be argued. So we will be backing up now. Preeta, can you please propose vote of thanks?